Good, good evening, everyone. My name is Shane, and I work at the Free Library of Philadelphia system in the Social Science and History Department. I just wanted to give a brief introduction as a co-host for tonight's program. In the History Department, we have a government and legal reference collection with complete collection of United States and Pennsylvania statutes and code books. We also have general legal reference titles for a host of issues, including divorces, how to file taxes, estate planning, like tonight's program, and many more. And we're happy to network and connect people with legal professionals. So that's why we're here tonight working with Pennsylvanians for Modern Courts. I also wanted to share that special consideration was given to a current exhibition at the Parkway Central Library. We have a program called Or Not to Be, which has representations of death. And so we have a bunch of different programs related and centered around that one subject. We have a special exhibition on our third floor. So if you'd like to see that, please consider checking it out. I'll leave a link to that information in the chat box. But I'll go ahead and hand it off to Pennsylvania for Modern Courts, who will introduce our speaker for tonight. So thank you very much for joining us.
Thank you for that, Shane. My name is Nina Schabach. I'm the Pittsburgh Program Coordinator for PMC, but I'm stepping in tonight. I'm here to tell you a little bit about what we do. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, accessibility, and respect. For over 37 years, PMC has worked to educate all Pennsylvanians about the courts and how to navigate them with confidence. While we are not offering legal advice tonight, we hope this presentation is informative and educational to you all, and you will be receiving these slides as a PDF if you've registered for the program. On behalf of PMC, thank you so much for joining us tonight, and thank you to the Free Library for hosting us. As I mentioned, you'll be receiving those slides as well as a questionnaire, and if you fill out the questionnaire, that really helps us with grant funding. So now our speaker for tonight is Maureen Farrell. Maureen is the owner and principal attorney at the law offices of Maureen Farrell, specializing in estate planning and litigation, business law, and elder law. And I'm going to get us some slides so we can get going.
Hey, thank you so much for having me.
All right, here are some future events. Again, these will be on our slides. Let's get to it.
Okay. Thank you, everybody, for joining us. My name is Maureen Farrell, and I am an estate planning and a probate attorney. I also help with if there's an issue regarding probate. For example, if there's an issue with a will that an executor wasn't chosen, or if there's an issue with, let's say, something that needs to be cleaned up in a will. So my sole area of practice is estate planning. Business comes into play, but elder law. So this is what I do day in and day out, and this is what my experience is. Usually I start off with a question. I'm not sure if there's a feature on here to answer, but I just wanted to find out if any of you have been through the probate process. So I don't know if there's a feature to answer. Nina, there probably isn't on here, but it's important to know if any of you have heard about the probate process or seen relatives and friends go through it. But it can be very complex, and it can be very concerning and grief. I see something on here. Nina, could you just tell me what somebody's answered that question?
Yes, about to go through it, hoping to avoid it, heard it's awful, heard of it, and no direct experience are a few of the answers we're getting.
Okay, so it can be exactly. So what we're trying to do tonight is give you some information so that you have that in your back pocket. Just if you have a notepad available, maybe to take a few notes, and just to try to avoid some of the awfulness, because it's an awful time in your family. Relatives sometimes are fighting. And so tonight's program is to try to just educate about some of the issues that I've seen over 21 years of practice happen. So the first thing I want to talk about is everybody on this call needs to have some kind of estate plan before we even talk about what happens after you die. This program is also about protecting you. So what I mean by an estate plan is, estate sounds like a very like rich and famous word, I always say. Every one of you has an estate. Some people may say, well, I don't really have one, but all of you do. Okay. And it's really important to make sure that you have that coordination of your estate. And that means having a last will and testament. Okay. And having that takes place after you die. Okay. That'll determine where your property and assets go after death. A durable financial power of attorney. And that is going to be utilized if you are incapacitated during your life. Okay. And you're going to pick someone to do banking transactions and other transactions for you. And then an advance directive, which is a healthcare, you're going to pick your healthcare agent. And there's also a part of that document that's called a living will, which means if you're alive, but you can't make decisions for yourself, your healthcare agent will make them for you. So I just call that the triangle, you know, I don't know, triangle of responsibility or whatever. There's a triangle of Bermuda, but you know, those documents should be coordinated. And so if you have a will in place, your probate, your administration of your estate after death is going to go much more smoothly. But it also depends on what kind of will. I don't mean a will that is just like a slipshod or whatever it is. I mean a drafted properly will that's signed at the end. Okay, in Pennsylvania, a will has to be signed and dated at the end. And it's important to have witnesses and formalities. But by having your will completed, you're going to save yourself up front a lot of time and money, because you're going to end up spending more money if you don't have one. Nina, I see there's a question. I don't know whether we should do them as we go or.
Those are resources from Shane, actually, but I will
Oh.
shout out questions as we go.
Okay, great. Thank you, Shane. But in any event, I get so into the program I'm talking to you, so the questions. But in any event, so when you draft your will, you're going to draft it according to, if you have personal property, okay, that means like all china and dishes and your car and your furniture. Also, there's digital property, which is like your Facebook account. I mean, I don't know how many of you have seen like someone dies and their Facebook account 3 years later is up, you know, and celebrating their birthday. So there'll be that part of it. There'll be charitable giving portions of it, of your will. If you have a pet in Pennsylvania, that the pet is your personal property. You want to make plans for your pet. I mean, some people say, well, I don't have anything, but you'd be surprised that you do have more things or more items and more assets and more sentimental value items that you can pass through your will than you actually think you do. And it gives you peace of mind when you have the will. Okay. Your power of attorney document is something that is going to enable somebody to make, like, if you're incapacitated, to go to the bank for you, pay a mortgage for you, do various legal tasks dealing with your funds while you're alive for you. And it's very important to get that document completed and make sure that's proper. I just want to focus your attention on the slide. So each county, okay, is going to have what's called the Register of Wills. And I'm speaking here in Philadelphia. And the Register of Wills in Philadelphia is in room 180, City Hall, okay? And so if you live in a different county, so if you live in Montgomery or Delco, at your death, the Register of Wills that you're going to go to is in the county that you reside, okay? So Register of Wills is in charge of after death probate, okay? And it's very important to understand that when you go to the Register of Wills for probate, that you have everything prepared, okay? So when you have everything prepared in advance, and you go into the Register of Wills office after someone died, you're going to have a much better experience. You're not going to get frustrated. I don't know how many times I've been in that office where someone is missing a death certificate, for example. Like someone has died and you need to have an original death certificate with you, not a copy. And you're coming into that room 180 and you don't have it, and you have to go and get it. So preparation is really important, especially at that time. So that's one item I just want to, on your items list, you have to have is an original death certificate. Typically the funeral homes will give them to you. I always tell everybody to ask for 5 to 10 because you're going to need many of them, and you're going to need originals most of the time, not necessarily copies. Okay, so here are the slides talks. It just gives definitions of probate and estates, and you'll have all these later, but I'm trying to give you information that you're not necessarily going to get from the slides. We can switch to the next one. Okay,
Right.
so we're talking about probating an estate. Okay, so what I just said was if you have a will, and your will is going to give away, well, will is a contract, okay, after death. So do I need to open up what's called a probate? Okay, so what probate really means is after you die, if you give away, let's say you give away $10,000 to your sister, okay? What you're doing through that will is you're transferring that $10,000 to her, okay? So that by doing that, you are probating. So you have to probate the estate because think of it as a transfer of an asset. Okay, so there only certain, this is a really important point. There are only certain assets that get transferred under your will. Okay, and those assets are subject to probate. Okay, so assets that get transferred under your will are assets that are in your sole name. So, for example, if you have a house that is in your sole name, you're going to have to transfer the house to somebody at death. Okay, so you're going to have to name somebody in your will to take your house. Okay, many of you probably have your house in what's called joint tenancy, so that the house will immediately pass to a spouse or a partner. It's not going to pass under your will. One thing I'd like you all to do after this too is an organizational task. Just see what documents you have, where they are, like if you have a deed to your house you haven't looked at for a while, make sure you have that. They're online in Philadelphia. I've dealt with some deeds that are actually incorrect. The description is wrong. Things happen. Okay, so will give away so if you have a checking account in your own name, then you're going to have to give that money through your will. But if your checking account is in joint names, it's not in your sole name anymore, then that will go to whoever you have listed as the joint account owner. Okay, so this is a planning tool where you may want to avoid having to probate. Okay, the way you do that is you start changing titles to accounts. And that's what I do a lot of times. If people want to avoid probate, they don't want to have that awful experience, maybe they'll change their house to like joint tenant so they don't have to probate, or change their checking account to have a joint checking. So these are things you have to think of. Probating is a management, the court then is managing your estate, and you're going to have to go to the court and provide them with certain documents that are required in a timely manner. Okay, so on here, there's talking about non-probate property. Just remember that probate property is property that you're giving away that is in your sole name, and a will is a mechanism to do that. Okay, so this slide talks about real property, so that also is by deed. Okay, so that's another thing you want to make sure that your deed is proper. Thank you. Okay, so there's a whole list of whether you want to probate your estate, whether you need to probate an estate. And it's very important in terms of probating timing. Okay. So let's say you have a will, okay, and you want to make sure you went to an attorney and you have a will, you want to make sure that you have the original will. Okay. This is the one document. There's not a place at the Register of Wills office in room 180 to lodge your will. Okay. So this has happened to clients before. They have lost their will, okay, that they've paid money, good money to have completed. And once you have lost it, you don't have a will anymore. Okay. So once you get that will drafted, make sure the original is protected. There are different fireproof safes available, there are safe deposit boxes, and make sure that people, if you want them to know, they know where it is. Okay. The last thing you want to do is, where is it? I have no idea. So, and the original will be presented over at City Hall, not a copy. Okay, a copy is a whole different story. And if you only have a copy, you're going to have to ask the court if you can probate the copy. And that's very expensive because the court is not going to think the copy is the original. Okay, so you're going to have to prove it. So make sure, and you keep that will safe. You keep it protected, no spilling, no rips, no anything, because you don't want it ever questioned that it's not an original. Okay, now if you don't have a will, then you're going to have to go through a different sort of process, and you're going to have to determine who's going to actually be in charge of probating when there's no will. So this is something that I've had family members that disagree about. Okay, I want to be the person, there's no will, but I want to be the person in charge. I want to be the executor or the administrator. And that creates a lot of tension. So having will, in that will, you're appointing the executor. Okay, you're appointing in your will who is the person who's going to be in charge of going over to room 180 City Hall and managing the estate and making sure it's done on time. Okay, so I would highly recommend, because you want to have the person who's responsible in charge of being the executor. Next slide, please.
We have a question first.
Sure.
If I pay a mortgage on a house and want my house and mortgage to be transferred to my kid and make them the executor and name this all in my will, do they need to probate the estate? This current slide confused me a bit.
Yeah, what was it? Could you just repeat the question one more time?
If I pay a mortgage on a house and want
Mm-hmm.
my house and mortgage to be transferred to my kid and make them the executor and name this all in my will, do they need to probate the estate?
So yes, so if you're transferring, I just want to make sure I have, if at death you have a house with a mortgage, right? That's what you're saying. So then there's sometimes what people do, just a little bit off the subject, is people get life insurance or some kind of insurance to pay off the mortgage when they die. Okay, so if you're transferring the house and the mortgage to your children, not by deed, but through will, yes, you are going to have to probate you're going to have to probate your estate. However, you can transfer the house by your deed, let's say while you're alive, okay, to your children, but that's a whole different story. But yes, you can, and so you can make that person, your child, or the executor as well, so that that person is in charge of making sure everything is transferred. Did I answer that for you? Also, I just want to make sure anybody that has a question, you can give me a quick call, and I'm happy to go into more detail, because tonight we have to get through a lot of material. So, Nina, did I answer that for the person?
Yes, the answer
Okay,
is
great. All right. So a lawyer to probate estate, I mean, everybody knows I'm a lawyer. And so, it's back to the, do you want somebody to first off, be an expert and assist you with this and have a relationship with someone? I'm a big relationship person. So I like, so like if I'm going to, an accountant or whatever, even like somebody who likes sports, that they like sports, you ask them a question, you know what I mean? So it really depends on you, but I mean, I don't think, like, it's kind of like, if I have a simple will and I go to LegalZoom and do it, right? And something's wrong with it, I'm going to end up paying in the back end, right? So, and LegalZoom is not good for every state. It's literally for the entire like United States. Like Pennsylvania, I draft a Pennsylvania will. Okay. New Jersey, you draft a New Jersey will. And like, and so it's really up to you what you want to do. If you want to spend the money now, I mean, you'll spend the money now and make sure it's done right. But if you do not have a will, you're going to have more issues, especially, and this is the biggest thing. If you have a complex family, if you have a blended family, if you have complex assets, and if you have complex questions, you need like even that coordination, what I was talking about. You need somebody to assist you. And you can always go, this is my thing, you can always go for consults with a lawyer, just spend the money with a consult. If you feel like it's worth it, you know, you can like continue to go to that lawyer or not, but at least do some kind of like even check 3 lawyers, see who you feel comfortable with, but at least do some kind of checking, because I would hate to see you have to go through more grief on the end, you know. But if you have a very simple estate and you feel like, or if you feel like I don't have anything to give by will and it's all through joint accounts, maybe you don't need a lawyer to do that. All right. So now we're talking about the different types of estate, which I sort of touched on. So a testate estate means that you have a will. Okay, so you died and you have laid out your wishes in the will. Okay, and you have a will that's signed at the end. That's really important for everybody. If you leave this program and you write up your will and you sign it and date it at the end, you could have a will. Okay, so now I'm talking about going to a lawyer, but I'm also talking about you could sign, you know, in your own hand, sign it at the end. I'd rather have you have something than nothing. Okay, and date it. All right, so that would be a testate, and you have to be able to read it though. No computer also. Okay, so that would be testate with a will. Intestate is when you don't have a will. Okay, so that is where you're going to have to pick out who's going to be your, when an estate is intestate, it's not an executor you're picking, it's an administrator. Okay, so what's going to happen is you're going to decide, okay, somebody died. Okay, it doesn't matter who, let's just say it's a grandparent. And there's all like grandchildren and children. One of you will have to be the administrator. And so the others that do not want to be the administrator have to actually what's called renounce. Okay, they're not renouncing this. This is also important. When they renounce, they're not renouncing their estate portion. They're not renouncing like if they're a beneficiary to some of the money, they're not renouncing that. When you fill out the renunciation form, you're just renouncing that you don't want to be the administrator. I mean, that's a really important point, because sometimes clients feel like, oh no, if I renounce, I'm renouncing some other assets that I'm entitled to. It's not the case. Okay, you're just renouncing that you don't want to be the administrator. And just one thing about being the executor or the administrator, there's certain rules you have to follow. Okay, so when you're the executor, I always say, like, there are deadlines. If you're a person that's good with lists and following deadlines, and also if your family's contentious and gonna bother the executor, like I have this sometimes, when are you going to give me my money, or when is this going to be out, or when are you going to sell the house, and this and that. So sometimes the executor really needs a lawyer, because if they start getting bothered and by people, that's like, when are you going to pay the mortgage? When are you know, these things take time. You've lived your whole life. And so it's very important that the executor knows that they can hire an attorney to help them. And the attorney will talk to the other heirs and say, you know, this is what's going on with the estate. You want to be careful when you talk about what's going on with the estate. Okay, because let's say there's 5 or 6 heirs, and you're the executor, and you start talking more to one heir, and you start saying to the one heir, oh, you know, this is this and this, you could be accused of favoritism. Okay, so and not being impartial. So executor job is not for everybody, okay, and it's not an insult. Some family members get very insulted that they weren't chosen. I would discuss this with your attorney, who you think should be the executor, okay, because that person is going to make sure that whatever you put down as your wishes are what's going to happen. Okay, so just a point, there's 9 months that generally you have to pay what's called inheritance tax in Pennsylvania. Okay, so that the estate should try to wrap that up within 9 months. I have estates that last for 4 years, and they're very complex. Okay, and there are a lot of fighting. There's a lot of that, so they can last for a while. So this is back to the original we talked about. Try to avoid that. Try to do things to avoid fighting. But the executor, if they need an attorney to help them with contentious beneficiaries, they should definitely hire one. Okay, it's really important. Okay, next slide, please. All right. So this is what we were talking about, the executor. I just want to bring up a point about the executor. So when you're choosing the executor in your will, and the administrator, remember, would be intestate when you don't have a will, you really want to make sure you have a backup too. So another goal for this program is, if you have people that you're thinking about, jot those down. But like, in case that person, you don't know, sometimes people don't, you know, for whatever reason, they have a different job or they're not available. You want to have, and it's not uncommon for someone that you've chosen to just say, I need to pass this off to somebody else. Okay. And it's nothing personal. So I would always, for any of these positions, these fiduciaries we're talking about, definitely have a backup. And because you want to avoid that administration that I talked about, like people having to renounce. You don't have a backup. You know, you have to ask the court then for the backup. So definitely do that. I do not recommend co-executors. Okay, co-executors are always a problem. Okay, and because what happens is, if you have 2 siblings, let's say you make co-executor, they have to agree on everything. Okay, so if they have to agree on everything and they don't, you're gonna have a problem. And they have to sign everything. So like when they go to the bank to set up like an estate account or something like that, they both have to be there. And it can be really cumbersome, you know, for them if they can't coordinate their schedule. So I do not recommend co-executors. I recommend even if you have 1, 2, and then a third backup, that's fine. But have the person just one individual for that. I want to check my time. It looks like good on time. All right, next slide.
Okay.
All right, so we were talking about what you're going to do. So now we're fast forwarding to actually, like, someone has died, okay? And this is probate steps. So let's just say they have a will. Okay, so you're going to find the original will that's in your safe, and you are going to get the death certificates from the funeral parlor. And usually the funeral parlor contacts Social Security as well, to stop that. That's just what I've encountered. But anyway, you may have to do that. That's the next step. But so you're going to get a copy of the death certificate. You're also going to make sure, when you go to the Register of Wills for probate, you have an idea, okay, in the will of what the assets are. Okay, because what probate is, they're going to ask you this question. The question is, what is the approximate value of the estate? So there's the value of the real estate. It's 2 separate things you're going to have to know. They're just saying approximate right now. So what is the approximate value? Like that question about the mortgage, just the real estate. Okay, not the mortgage, just that property. And then what is the approximate value of personal property? And what they mean by that is everything else. So the real estate and the personal property would mean whatever's in your checking account, okay, your savings account. If you have a CD, stocks and bonds. Those have to get liquidated when you die, okay? But remember, those other accounts, if they're joint, those are not probate assets, so you're not listing those. So if your house is in joint names, you do not have to probate the house, okay? But if it is not in joint names, you do have to list it. So you're going to get a fee for probate based on the value, in part based on the value of the assets, okay? So there is, on the Register of Wills, you can go to the website. I don't have it on hand, but they'll list, okay, if my estate is between like 500,000 or, and then $1 million, or 1,000 and 100,000, they'll list what your probate fee will be based on your approximate value. Okay, so there are strategies for this. So if you want to limit paying a probate fee, Pennsylvania does not have high probate fees. Okay, just so you know. Florida is a whole different ballgame. Each state has different fees. So you can check that chart, and so you can decide, okay, do I want to make my checking account joint so I don't have to pay a fee? You know, there are some fees on there for other things that are just going to be government fees that are set. Okay, so those you're not going to get away from, but probate will be, now if you have charities that you want to give away, there's no fee when you're giving away to a charity. Okay, so that's a whole different story. But the fee on your personal property would be what I was talking about, like cash too. If you have an auto, like a car, that'll be a fee on that. They'll ask you, like, if you have personal property, like art or coins or stamps, or like, what is the approximate value? We know you don't know the exact value at that point, but they will, the clerk, when you go to probate your estate, will ask you that. You definitely want to bring a form of ID with you, a government ID. And they don't accept personal checks. They do accept, though, they have the bank, like the card. So they have the machine you can tap when you leave to pay that probate fee. And then what's going to happen is you're eventually going to get in the mail the letter. They're called the letters testamentary, or the letters of administration if you don't have a will. And it's really like a nice document. It has a gold seal on it. It's you want to make sure you keep that document safe, okay, because you're going to have to present that. When you go to the clerk, so just the steps, when you go to room 180 and you bring those documents, you should go to this. I've learned this from experience the hard way. Attorneys can't make appointments, but you want to, we can't make appointments, but you want to go early. So I always go like 8:30, because you can sit there. I've gone on my lunch break and it's 2 hours. So try to get to room 180 in City Hall. You have to go through security like 8:39, and you'll be the first one. That's the most important, like, just to get that done, because it's really that also that this process is onerous, and like it's not fun. So if you get that done early, it's helpful. So you're going to go there and you're going to sit down with a clerk, and they're going to start asking you these questions that I just asked you. And one thing I just want to mention, if someone is incapacitated, okay, meaning they have dementia, early signs, or Alzheimer's, any of that, they cannot serve as executor, okay, and they have to step away. So that's another reason to have a backup. And the clerks can tell, okay, sometimes if they do. And I had an incident in my office. I was there, and somebody was trying to get somebody appointed that didn't know what they were signing, and they red flagged it. So that's another thing. When you get these will, you cannot draft a will if you have dementia or all these Alzheimer's or any of that. If the attorney believes that you don't understand what you're coming to the office, they're not going to be able to do it. So this is another protection for you. You don't want to be in a position where you've gotten like some kind of illness, and the attorney won't draft because they can't. Okay, it's ethically unsound. And you go over there too with someone who's an executor that you chose that has capacity issues. You want to be careful with all these kind of things. Okay, it's very important. And you'll take an oath when you're there. So they're going to ask you to raise your right hand, and they're going to ask you to make sure that you're going to probate according to the Commonwealth of Pennsylvania laws. And you're going to sign like a pad that has the digital sort of signature. You have to sort of, I've had to press really hard with that, just so you know, but it can be pretty quick. But if you have an attorney for that, so if this is just if you're doing it, you can bring a friend. But if you have an attorney, what I do is I send in all the documents online first. So it's very quick. So that's one benefit to having an attorney. The attorney can log in online and send everything in advance of the appointment. Next slide, please. Okay, so when you go to your appointment, this is one of the sheets you would bring. It's called the estate information sheet. It just gives like a lot of this stuff is very administrative. You know, when you go into the doctors, you fill out all those patient forms. It's kind of like that. Okay, so this is one of the forms you're going to fill out. It's just kind of for tax purposes. It's just some basic information about the executor, the address. So this is something like, as the attorney, I would fill it online in advance. You'll have this form in your packet. You can fill it out in advance. Okay, you're going to bring this to your appointment. But it's just really basic information that you're going to bring. Next slide. All right. So this is the petition. It's also like they call these things like petition of grant of letters, and they make them sound like much more. I mean, they are legal, but they're not as cumbersome as the title may make them seem. So the petition to grant of letters is just when you have a will and you're giving some basic information. If you look at the slide on the right, they're talking about some of the fees there. Okay, and one of them is called for a short certificate. Okay, so I discussed the sheet with the gold seal. That's eventually your letters that you'll get. A short certificate is just a shortened version of that. Okay, and I usually recommend for the short certificate getting 5. They're $10 a piece, but you want to bring short certificates so you're not the letters of administration or letters testamentary is like a bigger document. The short certificate is just a shortened version. And I would recommend getting a few of those. Okay, so that is one of the line items on that document. So that's something like, as the attorney, they always ask, like, how many of these do you need? I'd rather you have more than go somewhere and you don't have one. But you're gonna, at the end, you see where you take that oath and you're gonna sign. So, I mean, this is just some information you're gonna have to provide to them. And this is, I think, relatively straightforward. I'm happy to answer questions about this as well. Okay, so we were talking about the 2 different letters of administration and letters testamentary. So letters of administration and letters testamentary, once you complete your appointment at the Register of Wills, and you're going to tell them who the executor, it's the executor that's coming and doing this, by the way. So the executor is going to get either letters testamentary or the letters of administration sent to their address. In Philadelphia, you don't get the letters right away. In Delaware County, you do. Okay, you get them right then and there. Okay, so usually I provide, and you can do this too, and ask them, they'll like this if you do this. Like you can have like a stamp and an envelope and say, do you want my self-addressed stamped envelope? Because they'll put like the letters testamentary or letters of administration, and they give you a packet. And it's really well done. It's a packet of like, okay, this is when you have to do this is when you have to do that, and it'll lay out what you have to do. Okay, so bringing that self-addressed stamp envelope can be helpful to you, and usually within 5 to 10 business days. If you have not gotten it within 5 to 10 business days, I'd recommend calling them. Okay, but it's important because one thing about letters, you then, when you receive them, you're the fiduciary. Okay, so the executor is going to receive them. So until you receive those letters, you're not the fiduciary. You can't do anything until you get them. Okay, so if you go over to the bank and say, I want to close that account, they're going to say, well, where are your letters? Where's the death certificate? You're not going to be able to do that. Okay, so I would recommend doing this rather quickly so you can start acting. Okay. And you're going to have to do things. Let's say they had a house, the deceased had a house. You know, you're going to want to do things right away. Okay. You're going to want to protect the house. So make sure you get this done quickly. Don't wait, because you don't want to, let's say the decedent had a house. You don't want to leave a vacant house. Okay. In Philadelphia, there's a problem. We have a problem with squatters. And you also have to protect regarding insurance. This is a big thing. You have to have insurance on that house. Okay. So you've got to check your homeowner's policy, but insurance after death is not the same as insurance on the house during life. Okay. That's a whole nother program, but you really have to, I would say, just be timely, just get over there. You don't make an appointment, you just go over there. Okay. Next slide. All right. So these are the basic steps. So once you get your letters, right? Now you're going to be, I'm talking to the executor now. So the executor has the power to start making decisions. And so as the executor, you're going to have to determine, first of all, like, let's say there's debts. So there's medical debt, there's credit card debt. So there's different debts, and there's going to be money maybe to pay off debts. So you've got to be careful. There's an order of debts. There's unsecured and secured credit cards. There's medical bills. Things have to be paid first. Okay. So you want to assess, and also executors can get very, it's very overwhelming. Okay. So you've got to just take things step by step. Okay. And you don't want to just start making quick decisions and just start paying, because remember, you're the executor and you're working for the entire estate. Okay. What that means is you're working to manage that entire estate. You're not working for one of the beneficiaries. You're working for everybody. So you're there to try to make sure that's managed properly. Okay. So I had somebody that they were a victim of a roofing scam. Okay. And they tried to get money after the person died. And I told them no. Okay. So because they tried to get all kinds of money on a roof that they never really put on. Okay. And it was really defective. They tried to get some ridiculous, it was like $18,000. Okay. So you got to be careful about paying things, thinking, oh no, let me just pay this. Everything you get in terms of a bill, you have to investigate and make sure it's real. Okay. Because some of these things are not real. If they have a credit card, you want to stop the credit card, because you don't want the interest to keep accruing on the credit card. And you want to stop payment. You want to start advising that the person has died. Okay. And Social Security and things like that. As I mentioned, the funeral parlor typically would mention that aspect I've had. But I see there might be a question, Nina.
Yes. What if there's not enough money in the estate to pay all of the debts?
I know that's a great question. Whoever asked that. So that's an insolvent estate. So the way the debts are, like, you're going to pay certain ones first, and then you're just going to pay, like, funeral home gets paid first. And then they just don't get paid. So for example, a lot of times when someone's in a nursing home, let's say, and they have Medicaid bills, or they have nursing home debt or whatever, and it can be very high, the debt, and they're just not going to, they're going to get paid only what they can get paid. So that's so that issue too, it's important. Like, okay, if I'm going to be executor, this is like a practical concern. Do I want to be an executor and have this insolvent estate? That's an issue.
Another question. Can they make your loved ones sell a house with a mortgage because of unpaid medical bills if there are no
Right. So if there's money to be accessed, so back to that question, that's another good question. Thank you. So that context happens a lot of the time. Like if they're in a nursing home, right? And it's like, okay, you didn't pay, you benefited, but because you kept your house, then you have to sell the house in order to pay the debt. So yes, you cannot have a house and say, I'm going to keep this house and have all this debt. And yes, if they find out that you're keeping a house and not paying it off the debt, you're going to have to sell to pay the debt. Yes. So like, for example, if funeral bills, and then there's an order of debt. Okay. And so the executor has to be careful what I was talking about before to pay in the proper order. So like a mortgage needs to be paid. And so for example, this is another one, like a reverse mortgage is a serious issue too. They'll be like, you have to pay. And if that reverse mortgage is not paid, the interest will keep accruing. So that's a high priority of a mortgage that has to be paid. Was there another question, Nina?
Yes. How does credit card debt work in order?
So it depends on the type of credit card that it is. So if it's like an unsecured versus secured, I'd have to know which kind of credit card. But that's below. So like the higher priorities are like administrative costs, funeral. So that's like the funeral and if you paid people like the probate costs, all those things have to be paid. Those are first. And then medical bills. And I'm not exactly sure with the credit cards which ones come first. But it's definitely the secured comes before, but like a mortgage would come first. And then you start talking about credit card. Medical debt is before credit card. And then one thing to note that if you have government, like student loans by the government, those don't have to be paid after your death. So you get like a small favor there. But if you have private student loans, they get paid. But government ones are once you die, you don't pay those. Just a little tidbit there. But be careful, okay, with what you're doing. So that like all these things right here, transferring real property. So what does that actually mean? So does that mean you're going to sell the real property? Like what are you, is one of the relatives going to live in there? And are they going to pay rent? That is another issue that comes up a lot, where one of the relatives may have been living in there, or maybe a son or daughter was living and taking care of the person who died, and whether you're going to allow them to live there, they keep living there, whether they're going to buy out, okay, I'm going to live here, and what happens to the other heirs, like what happens to them. A house can be tricky. You want it, a lot of times the executor wants to simply sell. And sometimes, you don't want to have a vacant property, because what if you have a squatter in there, and then you have to keep up with remember, there are carrying costs on the property. So be careful what you're doing with properties, okay? Because this is the executor is in charge of all this. So I would be careful, changing the deed. One thing to note about the deed, as soon as the person dies, then it's an estate. It's the deed vests in the estate. Okay. So that's a whole nother seminar. We could talk about the deed and all that. I'd be happy to, but just for purposes here, be careful what you do. And I would recommend getting advice if it's complex, definitely. Next slide. All right. So this is just when you're prorating, you're going to have to provide, I'm already at 6:20, so I'll go quick here, but you will be getting the slides for all these. So I wanted to give you more like the tidbits from my practice a little more. So notice is a form you're going to give after 3 months. So you have to make sure that the heirs know they're getting something. I think there's a question.
Yes. What if the sole heir lives in a house that was left to them in the will, but there are more debts than the value of the house? Can they just kick you out?
Oh, so what if the sole heir lives in the house? So they were given the house in the will?
Left to them in the will.
Okay. And then there are more debts. So they have, and then it would be the executor who has to be in charge of if there are more debt, the debts have to be paid off. So the executor is going to have to, that's what happens a lot of times. You're going to have to sell the house. So that's an issue of like estate planning issue. Yeah. And also just one caveat, I'd have to see what these debts are too. We have to see what's going on with the debts. But yeah, if you're in a house and you're the executor's role, okay, is to pay, and another debt that has to be paid, the priority is the inheritance tax. Okay, so the executor is in charge. So let's say you're in a house, to that example, and the inheritance tax is 50 grand and the house is worth 40 grand, you're gonna have to figure something out. You're gonna have to pay that inheritance tax. So the tax comes before anything else. So that's an issue. And then if they had income taxes, those have to be paid as well. So yes, the answer to that, you're going to have to sell if there's more debts. But notices within 3 months, there's a form for that. You have to, as the executor, has to tell the beneficiaries that they might be getting something. And I have a certain way of filling that form out. And you do have to advise the court that you did that. Okay, because this is a way of beneficiaries to know that they might be getting something under the will. Next. All right, and those are the forms. We can skip this one.
Okay.
All right, thank you. So this is all as you're going through the probate, like this is probating, we talked about identifying assets. And opening an estate account is important, okay, because an estate is a legal fiction, okay? It is something you don't want to start, okay, you can start paying things that, like, let's say there's a death and you pay something out of your own account. You can reimburse yourself from the estate account. So, and what you want to do is you're going to set up an estate account at one of the banks. And so what you're going to get is you're going to get checks that have the estate of, let's say, Maureen Farrell on them, okay? So you will go to the bank and you're going to bring those forms I talked about. Usually they want the short certificate, sometimes the letters also, and a death certificate, and you have to have a form of ID. And then you're going to apply, I apply online for an estate account number. Okay, so because the estate's going to have a separate account number, it's like it's an EIN number, essentially. And you're going to apply for that, and you're going to bring that letter that you get from the IRS with you to the bank. Once you set up your estate account, you're going to pay everything. We're talking about paying debts and things like that through the estate account. And you can get a card with that too. I think you can take out, some of them have, like, you can only do X amount on the card for the estate. Okay, so one thing I want to get across with all these different tasks, and there's a lot of information on these slides, is that you want to streamline everything. You know, you want to go to probate, then you want to like decide what debts to pay. You want to go to the bank. The inventory is then going to be after 6 months when you figured out the actual values of everything. So remember at the beginning, I said there's an approximation of values. You're going to have to figure out, okay, how much is that house actually like worth? There's different values I use. Okay, so inventory is when you've decided, okay, well, I appraised that piece of art and it's worth X. Okay, the bank account on the date of death, the value was Y. Okay, so you're gonna have to go through and like figure out what values the assets have. Next slide. All right, so that's the inventory form. Just one thing, the inventory form is for probate assets. It's not for non-probate assets. Okay, so you're gonna list the different values on the form. One thing to note on the inventory form, if you approximated values and you didn't know, and the court knows that you don't know, and then it's higher on this form, the court will generally ask you to subsidize it. So if it's higher, they'll say, well, you owe $75 more for probate, okay, which makes sense because the estate is worth more. And that table that I talked about, let's say you said the estate was worth, I don't know, 10,000, it's worth 20,000 according to this form. Now you're going to have to pay them the register of wills. You're going to pay a little more on the probate fee. Okay, so it's just something you just need to know that you may get a letter just asking you to pay a little bit more. Next slide. All right, so filing taxes is part of your job as the executor, and so you're going to have to make sure when you're doing these tasks that I've been talking about, that you're keeping track of everything. So if you pay a bill and the bank account is good because you'll get the statements, but when you file the inheritance tax within that 9 months that I talked about, you're going to have to, there's debts that you paid. So for example, if you paid a mortgage off, that's a debt that you paid. So you get a deduction for a debt. Okay, so you're going to list like if you paid medical bills, you're going to get a deduction on your inheritance tax. So this is a lot of this administration, they call it estate administration probate for a reason, because it's got a lot of administrative clerical functions to it, but there's a precision to it. So the inheritance tax is called Form 1500, Rev 1500. It doesn't go to the IRS, it goes to the Department of Revenue. There's a distinction with the form. Okay, you can ask for an extension for the form, just so everybody knows, but that they can give you a 6-month extension. And we can talk about that too at a later date. Next slide. All right, we talked about paying off debts, so we can skip that guy. All right, and this we sort of, I just want to talk about executor's commission a little bit. So the executor can get a commission because sometimes they're doing a ton of, look at all this work we're just talking about. Okay, so, but you know, I would recommend putting the commission issue in the will, just talking about compensation. Some of my executors, their family members are like, no, I don't want to take anything. It really depends on the family, the person. But I mean, this can be almost a full-time job. So, I mean, I think it can be fair that the executor gets some kind of commission. I like to talk about it in the will, what it should be. There's different ways of valuing it. But that's also a family that can create conflict there. You know, like, okay, you picked my favorite kid as executor, and now they get a commission and they get more of the estate. You know, what you don't want is you don't want a will contest. Okay, you don't want that. So all of this has to be thought out in advance. Next slide. All right, this we kind of went over before, so I think we're good. All right, and now we're down to closing that. And I wish I had more time because there's so much to go over. And I really enjoy talking about this topic. But closing the estate, there's a status report that's due, and it's due 2 years. That's how long they give you. As I said, I have some that are 4 years going on. I mean, there's a lot that goes on. So, and the status report would just be like, you should, I mean, you don't have to. It's not in the it's probate, estate, and fiduciary code, but a lot of times the heirs may ask you for an accounting, and it can be an informal accounting of what you've done. So, I mean, that's, you know, if you start making decisions and at the end, you're going to have to show what you did. Okay. Like a balance sheet type of thing. And you're going to have to tell them, you know, you could distribute the money. So this is the whole thing. Sometimes you'll get heirs that really need money and they'll want it. And that's back to that debt, that very good question about debts. If you start giving an heir money and you have debts, that haven't been paid, it's a serious problem. Okay. So, and some people, just when you're closing this, they may have government benefits they're receiving, and you have to be very careful when you're planning your estate, because some people cannot get inheritances if they're receiving government benefits. So this has to be planned in advance, either with like some kind of special needs trust if you're receiving benefits, or some planning. Okay, so that's something to think about. Am I getting benefits? And if I get an inheritance, is that going to cause an issue with my government benefits, cause them to stop for a while, cease, or, you know, this has happened in my office as well. Not sure if there's one more slide.
Just questions.
Okay. And if you wouldn't mind, Nina, just giving my contact information for people. I'm not sure if that's on here. But if you could just,
I'll attach it in the email.
yeah, that would be great. But I think in wrapping everything up,